Hello, Federal viewers. Welcome to the special session where we break down the Supreme Court's latest opinion on the Governor President Assent controversy. Joining me here is the Federal's political editor, Puneet Yadav. Welcome, sir, and thank you for being with us. To start with, can you help us break down what the Supreme Court advisory opinion really means? What are the key takeaways from the verdict?
Yeah, so you see, this is in reference to uh, a judgment that the Supreme Court, a two-judge bench led by Justice Pardiwala of the Supreme Court, had passed in April uh, in cases related to, or filed by the Tamil Nadu government, where there had been this constant tug of war between the state government and the governor, Mr. R.N. Ravi, appointed by the center, wherein the governor was constantly withholding his assent to bills that were sent to him by, after clearing the state assembly. And so, when this matter was heard by the two-judge bench of Justice, led by Justice Pardiwala in the Supreme Court, uh, they had set out various timelines within which the governor must respond to a bill that has been referred to the governor by the assembly. Uh, you know, Now the response can be either you give an assent, as in you approve the bill, or you withhold it, or you refer it to the president, or you withhold it, withhold the assent, but return the bill to the assembly, in which case the assembly can then, pass it again and send it again to the governor, or can rework the bill. These were broadly the four issues that had been discussed during the case, and eventually uh, the timelines that were set by the two-judge bench were not just for the governor but also for the president. Okay, that if a bill is referred by the governor to the president, then what is the timeline that the president must follow? Now, right after this judgment by Justice Pardiwala came, there had been very polarizing views on whether this was a case of judicial overreach or even judicial misadventure, where can the Supreme Court uh, tell a governor or even the president when to decide, how to decide on a bill. And so eventually the president of India had made a reference. It had 14 questions. A reference was made to the Supreme Court to give advice to the president on those 14 questions. Now, today, after the presidential reference was heard, uh, for several hearings by a five-judge bench led by Justice B.R. Gavai, the current CJI, and in a nutshell, there are broadly 8 points that the court has today ruled, or outlined, I would say, in its advice to the president. And without going into a lot of legalese and jargon, I'll break them down into very simple, easy to understand layman terms. So the first thing that the Supreme Court has told the president in response to the presidential reference is with regard to Article 200 and 201 of the Constitution, which outline, the whole thing of whether a governor or a president, what is the time, can be bound by a timeline or not. Basically, what is the process of giving assent or withholding assent or returning a bill? Now, there they have said that the wording of Article 200 and Article 201, which govern the governor's mandate and the president's mandate, respectively, does not specify timelines. And it gives elasticity in terms of how much time is allowed to consider their opinion on a bill. And so, giving out a timeline, as was done by the Justice Pardiwala bench, will be very contrary to these principles. So the first point The court has said no timelines can be set. Point number two, the Justice Pardiwala had also said that, the two-judge bench had also said that if the governor's response to a bill is withheld for a considerable period of time, then it will be considered as deemed assent, as in he has given his approval or she has given his approval, her approval to the bill. And the presidential reference was whether there is such a thing as deemed assent that can be allowed. So the court has today said in its advice to the president that there is no such thing as deemed assent. Give any concept of deemed assent is like usurping the powers of a governor, usurping the powers of the president, and so it goes against the spirit of the constitution, and it also goes against the doctrine of separation of powers. The court cannot act on behalf of the governor, the court cannot act on behalf of the president. So that's point number two. Point number three, in terms of a bill that has been, say, withheld by the governor or by the president, or uh, has been returned to the assembly in certain way, or in that case, the only thing which will allow for judicial intervention, the court uses the word limited judicial scrutiny. So what the court essentially says is that the governor's, the merit of the governor's action cannot be gone into. The court cannot look into how the governor is acting, what it is doing. What the court can do is a very limited scrutiny in terms of and in case where a assent has been withheld for a very long time. Now that long time has not been defined because the verdict says no timelines can be given. So limited scrutiny can be done, and one understands from the way the advice is worded that it has to be done on a need to on a kind of need to need basis, as and when a bill is withheld, as and when there is a problem of bills being languishing indefinitely with the governor, then on that specific bill a petition can be moved in the Supreme Court asking for directions, but it can't be blanket deemed assent as the Justice Pardiwala bench had given. The next issue is, what were the options that were available to the governor when a bill is sent to a governor? Now, initially, the arguments were that the governor has four options available to him or her. The first option being you give assent, the second being you withhold assent, the third being you withhold and return. So you don't give your assent, you simply return the bill to the assembly. And then is you refer it to the president for further, for the presidential action on that bill. So the court today has said that the option of withholding without returning to the assembly, as in the governor is sent a bill and decides not to do anything at all, which was the case with Governor R.N. Ravi. That particular thing cannot be allowed because it is against the federal structure. In effect, it sort of cripples the legislative agenda of a state government because there is no forward movement. If you assent to a bill, you know that the bill has been approved. If you return it, the assembly has the option of passing it again and sending it again to the governor. If you have sent it to the president, there is still some amount of action happening because now you're waiting for the president to give her nod or return the bill. But what happens, as was the case with Tamil Nadu, when there is total silence, and so that option, the court today has said that the option of withholding without returning does not exist. It is against the concept of federalism. Uh, the fifth point that the court has made is the presidential reference had asked whether the governor must be bound by the aid and advice of the cabinet when a bill is sent uh, under Article 200. So, what that essentially meant was if I am the state government and I am sending a bill to the governor for assent, the understanding would be that the government which is passing the bill will not tell the governor not to give assent. So in that case the court has today said that the governor can does not need the aid and advice of a government when deciding on a bill sent under Article 200. The sixth point is in terms of a governor's action, what kind of scrutiny can be done. The court has said in layman's terms, if I were to put it, that the the actions of the governor cannot be reviewed by the court. It is only the inaction of a governor that can be reviewed, in the sense that the governor sitting on a bill indefinitely without providing any reasons, that will attract limited scrutiny, as I explained earlier. But a governor saying that he's, not giving his assent, or the governor saying he's sending it to presidential for presidential reference, or is withholding assent and returning the bill to the assembly, that cannot be challenged. The next point was whether, in terms of when a bill is there with a governor, can the bill be challenged in court? Can the court weigh in on a bill that has not yet become a law? There again, the court has said that a bill can only be challenged once it has been turned into a law, which means the entire process of passing through the assembly, the assent of the governor, the ratification, all of that has been completed. Then it can be challenged. But at the stage of a bill, it cannot be challenged. So, broadly speaking, these are the points that the court has laid out in its advice to the presidential reference today.
So looking ahead from this point, what impact does this have on the center-state relations, especially in opposition-ruled states where governors and governments are already locked in political frictions?
Yes, so this is where I think the judgment will now kind of open or reopen rather a lot of problems for states that are ruled by the BJP's opposition parties. Because the grounds, like in the Tamil Nadu case, of the opposition parties has always been that we send bills, we try to clear our legislative agenda, enact laws for public welfare or, general course of administration. But then, because the governors are appointed by the center, by the BJP, they want to cripple the functioning of opposition ruled states, and they do not decide on those bills. They neither give assent, they neither, make a presidential reference, they sit over it indefinitely. Now, because as I've said earlier, there are no timelines. The court has made it very clear that there will be no timelines. Only limited judicial scrutiny in terms of inordinate delay. And inordinate delay, again, is not explained. So, this problem will become a recurring problem. And it will become a tool in the hands of the center in terms of any state that any opposition ruled state that the center wants to trouble in terms of its lawmaking process and social welfare agenda and all of that. All that needs to be done is to tell the governor, sit over the bill, don't give your assent, or send it for presidential reference. And that was the very root of these whole petitions. So in a way, we're back to square one, or all opposition ruled states will now face the same challenge that they were facing before the April judgment, by the two judge bench, that there are no timelines. The governor decides at leisure, at his or her own pace, or doesn't decide. And so, what is the government supposed to do in that time with that particular agenda? So, in terms of federalism, I would say it's a big blow because fine, one understands that the court may have, in the view of many, including now the five judges who sat and delivered their verdict today, that the Pardiwala led bench had overstepped by giving out timelines. But then the basic question remains unanswered. What happens what is the implication on governance, on administration, when you clearly have an acrimonious relationship between the center and the state, and the center uses its governors to cripple the functioning of state governments and their legislative agenda? So you're back to square one in that sense. And in terms of center state relations, this will become a another strenuous issue. Uh, what one may even, people who perhaps take a more pessimistic view of, the implications of today's verdict, what they might also think is there's nothing here which stops the center now from perhaps bringing in a constitutional amendment. Maybe in the next session or the session after that, they have 4 more years to go. So at any time during these 4 years, uh, giving the governor more powers in terms of what the governor can do with a bill. So there are also going to be those fears in the minds of the opposition ruled states and parties. So in that sense, it's a big blow to federalism, to center state relations, and particularly to opposition ruled states.
Yes. Thank you so much, sir, for giving us your perspectives. For more in-depth discussions, keep watching
Thank
The
you.
Federal.